Have you ever walked out of the court thinking the judge just didn't like me? They were biased. They didn't even listen. Here's the uncomfortable truth. Judges don't usually hate people, but they do react very strongly to certain behaviors. And those reactions can quietly destroy your case. Today we are breaking down why judges lose patience, what behaviors instantly damage your credibility, and the subtle mistakes that make a judge switch off, even if your case is legally sound. Because in litigation, winning is not just about being right, it's about being believable, disciplined, and trusted. What if the judge's attitude is actually a mirror? Judges are trained to be impartial, disciplined, and evidence-focused, but they are also human decision makers under pressure. They manage tight court schedules, incomplete evidence, and combative lawyers. So when something goes wrong in court, it's usually not about your personality. It's about what your behavior signals. Judges don't react to your personality, your background, or your accent. They react to credibility signals. Court is like a high-stakes interview. The interviewer needs to assess your credibility by observing how you react to questions under pressure. You may be qualified, you may be the right person, but if you behave badly, inappropriately, or disrespectfully, the decision maker stops trusting you. Now let's turn to some big no's that trigger distrust. What's the fastest way to lose a judge? Don't answer what you will ask. This is the most common mistake. Take this as an example. The judge asks, "Did you sign the contract?" And the witness says, "Well, what happened was XYZ." What the judge sees is avoidance, evasion, and lack of honesty. What the judge expects is a yes or no or "I don't recall" answer. Then explain if needed. Why this matters? Because judges rely heavily on directness. If you can't answer a simple question, why would they trust you on complex ones? It's like asking, "Did you run the red light?" And someone replies, "I was having a really stressful day." The judge hears that as you are dodging, and it's likely you did it but refuse to admit your wrongs. It is silly to think you can outsmart the judge. A judge hears more cases in a single year than you will experience in your entire lifetime. If you imagine that you could play some tricks they never saw, you are absolutely wrong. Do you think being aggressive makes you persuasive? You may take advantage in real life by doing so, but it often does the opposite in court. Some parties think interrupting shows confidence, arguing shows strength, but in court it signals loss of control. Common bad behaviors include talking over the judge, arguing with every point, and refusing to accept rulings. If those events happened, the judge starts to think, "This person cannot be managed. This person is not objective." That creates obstacles for yourself to be trusted. Judges value discipline over passion. Court is not a debate stage. It's more like a surgical operating room where cases are dissected and where everybody is expected to be precise, controlled, and structured. If you start shouting in surgery, you don't look confident, you look dangerous. One inconsistency can destroy everything. If your story changes between affidavit and oral evidence, between documents and testimony, the judge notices immediately. What it signals is unreliability, reconstruction, and dishonesty. Judges don't need to prove you lied. They only need to doubt you. And once that happens, your entire evidence becomes fragile. Credibility is binary. You either have it or you don't. It's like a cracked glass. Even a small crack makes it unusable. If you don't know your own case, why should the judge? Common issues include not reading your own affidavit, unfamiliar with key documents, and guessing answers. What the judge sees is that this person is careless, this evidence is unreliable. Judges expect accuracy, familiarity, and ownership of your own evidence. Even honest witnesses lose cases because they look unprepared, lack of certainty, and have no confidence of their own evidence. The more dramatic you sound, the less believable you become. Unless you have concrete evidence or expert reports, try to avoid statements like, "He always lies," "I never lie," "She was manipulated," or "He must have forged the signatures." Judicial reaction to those statements are likely to be, "This is exaggerated. This is emotional, not factual." What judges prefer is precise, measured, and factual language. The fact is that understatement builds credibility. Overstatement destroys it. The courtroom has rules. If you constantly break them, you may lose before everything starts. Examples are ignoring directions, filing late documents, and failing to comply with orders. Judicial view on those behaviors is that this party doesn't respect the system. The consequence is that adverse inference may be drawn against you, cost penalties being awarded in favor of your opponent, and you or your witness losing credibility. So what actually works? We'll break things down in details in future if we have time. But for now, keep these things in mind. Answer directly, stay calm and controlled, be consistent. Admit when you don't know. Don't try to pretend you know or make up things, and respect the process. At the end of the day, judges don't need to like you, they need to trust you. Let me ask you, have you ever seen someone lose a case even though they were right? And why do you think that happens? Let me know in the comment section below. If you find these tips are useful, like, subscribe, and follow us for more legal insights. Thanks for watching. See you next time.